Thank you, everyone, for joining the webinar today. My name is Michael Hansen, Program Manager with the Action Innovation Network. Action is a collaborative network of technology business incubators and other entrepreneurship support organizations located throughout the New England region. Our network supports startups developing technologies across a wide range of tech industry sectors, including life sciences, clean tech, robotics, ocean marine technologies, and advanced materials, and others. Our Plymouth Rock project provides a suite of resources for international startups that are interested in exploring this innovation ecosystem as a place to grow their company in the US. A few items to review before we start the presentation. All attendees will have their audio and video muted. The presentation will be followed by question and answer at the end. You can submit a question for the presenters at any time during the presentation. If you have a question, just click on chat and use the chat window to submit your question to the host. This webinar will be recorded and emailed to you and also posted on the Action website for future viewing. Today's webinar, IP and Business Transactional Strategies as Life Science Companies Plan Their U.S. Market Entry, is presented by Beverly Yorth and Eugene Ho with law firm Verrill. Beverly has focused on intellectual property law for her entire professional career. She has extensive experience drafting and prosecuting U.S. and foreign patent applications in diverse areas of technology, including mechanical, civil, and environmental engineering, medical devices, material science, manufacturing, and computer-implemented inventions. Her practice also includes the preparation and prosecution of design, patent, and trademark applications. Eugene Ho counsels companies in all stages of their development, from startup through acquisition. He values his role as a trusted advisor and seeks to provide practical legal advice to all of his clients, taking into consideration their business and other objectives. Thank you, Eugene and Beverly, for presenting today. We look forward to your presentation.
Thanks, Michael. Good morning, everyone. As Michael mentioned, my name is Eugene Ho, and I'm a partner in the business law group at Verrill. My contact information can be found on the first and last slides of today's presentation materials. So if you have any questions after today's presentation that I don't get to answer in the Q&A session, or that you think of after the fact, don't hesitate to reach out. The topic of our presentation today is IP and business transactional strategies as life sciences companies plan their U.S. market entry. I'm going to be focusing on the business transactional strategies part of this presentation, and then my colleague Beverly will follow and tackle the IP strategies part. Specifically, I'm going to be addressing three topics: choosing the right company structure, choosing the right jurisdiction of formation, and then navigating CFIUS, or the Committee on Foreign Investment in the United States. So with that, let's jump right in. Got that to work, great. So choosing the right company structure. So for foreign companies, from a corporate law perspective, one of the first things you need to consider when thinking about entering into the US market is your company structure. At a high level, a foreign company can do business in the US in really one of two ways, right? Directly through a branch office or indirectly through a US subsidiary. I almost always recommend the latter course of action because there are really two significant benefits to doing business through a US sub. First, by forming a sub, the foreign company effectively creates a liability shield for the foreign company's non-US business. A central tenet of corporate law in the US is that the parent company of a corporation or an LLC is not liable for the obligations of its subsidiary. A subsidiary is considered a completely separate legal entity in the eyes of the law. From time to time, a court may, what's known as pierce the corporate veil and find a parent company liable for a subsidiary's obligations, but for a court to do this, it typically has to involve some sort of fraud or severe injustice or severe undercapitalization. It just doesn't happen very often. If it did, it would basically defeat the whole purpose of the corporate structure. The second significant benefit to doing business through a sub is that a foreign company effectively creates a tax shield for the foreign company's non-US business income. Doing business in the US directly through a branch office can, not to say necessarily will, but it can subject a foreign company's non-US income to US tax jurisdiction, which most companies obviously want to avoid. On the other hand, doing business through a US sub, if structured correctly, and I'll get more into this later, generally will not subject a parent company's non-US business income to US tax. So that's a significant benefit. Finally, a side benefit to the US subsidiary structure is that it can also better accommodate investments and divestitures. So For example, if let's say you have an investor that wants to invest only in the U.S. portion of the business, or maybe the company only wants to give the investor equity in the U.S. piece of the business, it'll be a lot easier for the investor or the company to do that, right? Because there would be no fear, or at least less of a fear of the investment getting commingled with the rest of the business. Also, if the foreign company wants to sell the U.S. business later, right, or a buyer only wants to buy the U.S. business, the subsidiary structure makes it a lot easier to do that, because basically the foreign company wouldn't have to unravel the U.S. business from the rest of the company. The U.S. subsidiary would already have its own bank accounts, it would have a title to its own assets, its own contracts, etc. So once a foreign company decides that it wants to form a U.S. sub, the question then becomes, what type of entity does it want to form? In the U.S., there are basically three main types of business entities: the corporation, the limited liability company, and the partnership. There's various types of partnerships, but that's generally the three. I'm only going to be focusing on the top two, the corporation and the LLC. It's just simply very rare for a foreign company for tax and other reasons to form partnerships. So I think it's something that basically foreign companies can effectively ignore. So let me go through briefly the differences between corporations and LLCs and the pros and cons of each. So corporations are the most frequently used company structure for foreign companies. 90% of the time when I form a sub for a foreign company, I form a corporation. They've been around for a long time, so they're sort of the most familiar structure. Foreign companies see this from the other side when they're entering into vendor contracts and customer contracts with U.S. companies. They see a lot of corporations. They have the liability protection that I was talking about earlier, right? Shareholders typically aren't liable for the business liabilities of the corporation. They also have what's known as double taxation. So double taxation is actually domestically in the U.S. one of probably the biggest disadvantages of corporations. Double taxation refers to the fact that a corporation is taxed on its earnings at the corporate level, right? And then when there's a distribution to stockholders, that income is further taxed. So there's basically two levels of taxation. That's typically not a beneficial thing for shareholders in the U.S. Internationally, however, this double taxation actually is generally a benefit in that, in effect, it acts as a tax blocker and shields the U.S. subsidiaries' activities from the non-U.S. activities of the foreign company. There are also other favorable tax consequences to corporations, one of which is that when a foreign corp sells its stock, basically any gain on that stock is considered offshore and not taxed in the U.S. That's a pretty big plus. Corporations are also preferred by investors, professional investors, that is. So professional investors tend to favor corporations for some of the same reasons we just talked about. It's familiar to them, so they feel comfortable that the corporate structure, from a corporate law perspective at least, will protect their investment. Double taxation is often a good thing for them, just because the vehicle through which their investors invest them necessitates a double taxation. Otherwise, a pass-through would create a bad tax consequence for their investors. So if professional investment is an objective, either now or in the future, that may be a factor that leans towards forming a corporation. So let's talk about LLCs briefly. So LLC, there's a definite trend of foreign companies forming more and more LLCs. For a while, LLCs were very new, so people were less familiar with them. Now they're not so new anymore. At least in Delaware, they've been around for almost 3 decades. So they're becoming more and more familiar. LLCs provide for very flexible management and equity structures, more flexible than corporations. They can be member managed, they can be manager managed. You can have different classes of membership interests. You can distribute profits in not according to ownership interests. They're a very flexible entity. Basically, you can make an LLC as simple or as complicated as you want to. Like corporations, they have the limited liability protection, as in the name. Unlike corporations, however, LLCs by default are taxed as pass-through entities, meaning there's no double taxation. So domestically, this is a big plus for LLCs. A shareholder or a member, as they call it in an LLC, basically only has one level of taxation. So that's a big advantage. Internationally, however, when income passes through to a foreign company, the foreign parent may be considered to be engaged in the U.S. trade or business of the LLC. And so as a consequence, that could expose the company's non-U.S. based income to U.S. taxation, which obviously is a bad thing. Whether it gets exposed or not, there's a number of factors that gets that becomes a factor. I'm not a tax lawyer, so that's not really my area of expertise. But the type of business, the type of treaties that are between the two companies, the U.S. and the foreign company, the transfer pricing between affiliates, all this will impact sort of the likelihood of exposure of the non-U.S. business income to U.S. taxation. Also, another sort of I would say sort of a disadvantage of an LLC is that the foreign company, from a tax perspective, will have to pay withholding tax obligations to the U.S. government on income that is allocated to the foreign parent, whether or not distributed. So this is in contrast to a corporation where a shareholder only gets taxed upon receiving the distributions. Basically, in an LLC, the foreign company will be deemed to have received the income, whether or not they've actually received it. So one wrinkle to all of this is that an LLC can elect to be taxed as a C Corp. It's known as checking the box, because there's literally a form that you fill out where you check the box and say you want to be taxed as a C Corp. So when I said earlier that 90% of the time I form corporations for foreign companies, the other 10% of the time, basically I form LLCs taxed as corporations. For clients, some clients really want the flexibility of an LLC. And they want the benefit of being, taxed as a C Corp. For others, they don't see the flexibility as much of a benefit. If anything, they see, being an LLC taxed as a corporation as kind of confusing. And so they just decide to just form a straight out corporation. That happens probably more often than not. But the key point here really is that the company structure decision will be driven largely by tax considerations. So it's important to get your tax lawyers and your accountants involved early. So, once you decide, a foreign company decides to form a U.S. sub, and then it decides to form, let's say, a corporation, right? Another decision that the foreign company will have to make is in which jurisdiction to form the U.S. sub. Corporate law in the U.S. is governed by the individual states. There's no such thing as federal U.S. corporate law. That means that a foreign company can basically form an entity in any of the 50 states and plus the District of Columbia. And there's no requirement that the entity establish operations or maintain its principal place of business in the state of formation. A company generally just needs to designate someone who resides in the state of formation to receive service process in case the company is sued. And many companies, they just hire a third-party vendor to do this, like a CSC or a CT Corp, and generally it costs a couple $100 a year. So how does a company decide where to form, right? So Delaware is overwhelmingly the most popular state of formation for foreign companies for a variety of reasons, some of which, frankly, are self-fulfilling. For one, Delaware has a modern corporate statute, which means it's reviewed annually and it's updated as necessary to clarify provisions and adjust the current trends. At the same time, because there are so many, Delaware companies formed, it has a significant large body of case law that provides guidance and predictability. So, Delaware has this ability to really just strike a great balance between being both flexible and stable. Delaware also generally has what's considered business-friendly laws. For example, it's very hard to pierce the corporate veil in Delaware. Delaware also has certain rules that facilitate the management of both day-to-day operations and significant corporate events. So, as an example, the stockholders of the Delaware Corp can act by written consent with only a simple majority. Many other jurisdictions will require unanimous consent of stockholders. In Delaware, also, you can affect a statutory merger or or sell substantially all the assets through a consent of the simple majority. In many other jurisdictions, that would require supermajority. Delaware also has what's known as the Court of Chancery. It's a special court for the resolution of business disputes. So corporate cases can get heard quickly, relatively quickly, and they'll be addressed by expert judges who are really experts in corporate law versus a potential jury trial. The Delaware Secretary of State's office is also very efficient in accepting and processing filings. You can often get same-day service. The Delaware statute is familiar to most U.S. corporate lawyers throughout the 50 states, so you generally don't need another lawyer to form the company for you. Your local lawyer should know how to do that. There's no state corporate income tax implications in Delaware, so long as you don't transact business there. That's a question I get a lot. And also Delaware, as with corporations, is preferred by professional investors. Professional investors just feel comfortable with the Delaware laws that that'll recognize their preferred stock status, will recognize their interests, so they prefer Delaware. So in effect, Delaware has made it a business of being sort of the go-to state of formation, and has been able to maintain that. One drawback to forming in Delaware, it's not a huge drawback, but it's the additional expense and administrative burden of having to also qualify in your home state, right, or the state in which you have your headquarters. So just to give a little background here, business organizations must qualify to do business in each state in which it does business. And what does it mean to do business? Unfortunately, most state statutes define doing business in the negative. In other words, it's they say doing this does not by itself constitute doing business. So it's never really entirely clear. But generally, among practitioners, a company will have to qualify to do business in another state. If they have an office there, real estate is a significant piece, or other significant sort of contact, if you will. So a U.S. subsidiary will have to qualify to do business in its home state. Qualification, typically requires a filing fee, a couple $100 a year, and an annual filing, with information about who your officers are, your directors are. So this additional expense can be avoided if you form your entity in the state in which you're headquartered in. So, because an entity formed in a jurisdiction effectively is automatically considered qualified to do business there. Is this a huge cost burden? Generally, no. But for startups that are strapped for cash, it's something to consider. So the third and final topic that I'll be covering today is the Committee on Foreign Investment in the U.S., or also known as CFIUS. So generally speaking, it's pretty easy for a foreign company to do business in the U.S. It's inexpensive and fairly quick to set up a corporation or an LLC. You don't have to be a U.S. person to own a U.S. company. At the end of the day, there aren't a lot of barriers to entry. At least not many barriers that are more than what a domestic company would otherwise have. One barrier that's different for foreign companies, however, is CFIUS, and CFIUS is becoming an increasing area of focus for foreign companies. So what is CFIUS? CFIUS is an interagency committee of the U.S. government. It's comprised of reps from, I think, 16 different departments, chaired by the U.S. Secretary of the Treasury, and it's authorized to review certain transactions, foreign transactions in the U.S. to determine their effect on national security. CFIUS advises the President of the U.S., who has the power to block or impose mitigation measures on foreign transactions believed to threaten national security. Some examples of mitigation measures include putting limits on the foreign investors' governance rights, right, the board of director rights. They can put limits on, the amount of information, the access to the information to the U.S. company that they have. They can require, that they divest of certain assets or certain contracts that are sensitive, or they may impose, certain ongoing compliance obligations to the U.S. government. So those are some mitigation measures. The general rule is that a foreign company can voluntarily submit to CFIUS review, or CFIUS can unilaterally initiate a review, with one exception that I'll talk about in a bit. But one important thing to note is that there's no statute of limitations for a CFIUS review. So CFIUS can basically initiate a review of a transaction at any time. So that's an important calculus, right? Do you initiate a review now so there are no surprises, and so you don't commit significant capital or resources and time without knowing the potential fate of the company, or do you take a chance and just assume that this is something that CFIUS won't sniff at? If there's a review, unfortunately, the process is not very transparent. It's a bit of a black hole, and the president's decisions are not subject to judicial review. Filings are not made public. CFIUS can consider a broad range of factors that implicate national security, and they don't have to disclose the specific factors that go into their decision. Obviously, some of the factors can be whether the company collects sensitive personal information from U.S. citizens, whether it's classified as government contracts, whether the investor has foreign government ownership, right? Those are some of the things they can look at, but they're never very clear necessarily what triggers a block or not. The good news, however, is that CFIUS clears the vast majority of transaction reviews. So most of the time it runs its course and you get cleared. So how does CFIUS impact the life sciences companies specifically, right? So in recent years, new rules have significantly expanded CFIUS's jurisdiction to non-controlling foreign investments and businesses dealing with critical technologies, critical infrastructure, or sensitive personal information. And historically, control of the U.S. company was a condition of CFIUS review, so this is a pretty big change. Each of these phrases, right, critical technologies, critical infrastructure, sensitive personal information, they're all specifically defined, right? Critical technologies is defined to include certain specified categories. Just as an example, certain nuclear facilities, equipment, material, certain defense services, things of that sort. There is one sort of vague category that's defined within critical technologies, which is emerging and foundational technologies, which has yet to be fully defined. And the technologies that comprise, emerging and foundational technologies is sort of it's being determined through an interagency process. So it's sort of a moving target. And in late 2018, when one of the agencies involved, the U.S. Department of Commerce's Bureau of Industry and Security, they published basically a notice of proposed rulemaking asking the public to comment on what criteria should be used to identify emerging technologies that are essential to U.S. security, right? And at the time, the Bureau of Industry and Securities identified 14 categories of technologies that they're under consideration. And one of those included biotechnology. Also, in 2018, a pilot program created sort of the first mandatory filing requirement by CFIUS. And this is, as I said, in contrast to what's normally what CFIUS engenders, right, which is a voluntary test, really. So this mandatory requirement was for companies that utilize critical technologies in 27 identified industries. So this is the two-part test, right? You need to first utilize critical technologies, and then you have to be in one of the 27 industries identified. Notably, one of the 27 industries identified is research and development in biotechnology. So in some, it's unclear where this will go. There's a lot that needs to still be defined, but I think foreign companies need to be aware of the possibility that CFIUS will have jurisdiction to review, potentially block and impose mitigation measures on, and at worst, at best, just delay, right, certain investments in biotechnology and life sciences. And it's clear, I think, that CFIUS is beginning to carefully scrutinize these particular industries. So with that, I'm going to turn the mic over to Beverly, who's going to discuss intellectual property considerations for businesses entering the U.S.
Great. Thanks, Eugene, and also thank you to Michael and the Action Innovation Network for the opportunity to present to you today. So I'm going to talk about the intellectual property considerations for businesses entering the U.S. So on the next slide, one of the first considerations is to have an IP strategy So a company should think about developing an IP strategy for entering the U.S. And this can include a number of factors. There's a list here which is not necessarily exhaustive, but it's something to think about. And the first one there refers to an inventory of a company's intellectual property assets. And these are typically patents, trademarks, copyrights, and trade secrets. And of these, patents can require a great deal of careful thought. Obtaining patent protection can be costly, so it's important to give some thought to determining which inventions a company would like to allocate its resources to protecting. And there's a few factors to bear in mind. Patents can be used both offensively and defensively. What are the important inventions and what are the less important inventions, and how can they be used? Would you anticipate wanting to license a patent to any third parties? That kind of thing. Also bear in mind that it is important to file any patent application before there's been any public disclosure of the invention. And this is things like other publications, offers for sale, and also even disclosures to potential investors. But that has to be balanced also with waiting until you have developed the invention enough so that you can actually draft a sufficient disclosure to support the claims in any patent application that you end up filing. Agreements can include things like confidentiality agreements, employment agreements with your employees, and also things like partnership agreements. And then there's a few other things on the list there that I don't think I need to go over, but you should be thinking about them at this point. So on the next slide, specifically considering patents, in the US, there are 3 types of patents: utility patents, which protect new and non-obvious and useful processes, machines, articles of manufacture, and compositions of matter, and new and useful improvements of these. There are also design patents that protect ornamental aspects of useful or manufactured articles, and plant patents, which protect certain new varieties of plants. Specifically regarding utility patents, there are 2 types of applications. There's both provisional and non-provisional applications. Provisional applications can be filed in the US, but they're not examined by the US Patent and Trademark Office. They can be more informal in nature, so they can be less costly to file initially. To claim the benefit of a provisional application, a non-provisional application has to be filed within 1 year of the earliest provisional application filing date. And that includes any international or other country applications as well. A provisional application can sometimes be useful for foreign companies. They're typically used to buy some additional time to determine the commercial viability of an invention before actually committing to filing the full-blown patent application. Also, provisional applications are not published, so it's a way of keeping an application secret until you've determined whether or not you want to go public with an application. Also, in the US, if you file only a US patent application, non-provisional application, you can request that it not be published at 18 months from the earliest filing date. That can only be done if you are foregoing any other foreign applications, however, and it needs to be requested when you file the application. So that can sometimes be a strategy for companies that only want to patent in the US, not necessarily for companies that are foreign-based, however. Some further aspects of patent protection on the next slide. So the U.S. is a party to a number of foreign conventions and treaties, and probably the most important one is the Paris Convention. The Patent Cooperation Treaty is also important for patents. It allows the ability to file an run international application, and from that you get a search and a written opinion on patentability, and then you can decide where you want to file national applications. The U.S. can be designated as one of those countries. And the Hague Agreement relates to design applications. And so those are things to keep in mind if you are thinking of entering the U.S. For certain patents. The U.S. is now a first inventor to file jurisdiction. So this puts an emphasis on filing patent applications early to secure a filing date before any prior art becomes published, or before perhaps a competitor working on a similar technology files their application. Prior art includes things like published patent applications and patents, published publications, offers for sale, anything that makes the invention publicly accessible. Think of that as being prior art. It is possible to institute what's called a derivation proceeding in the U.S. to determine if one inventor derived an invention from another inventor, if you do have competing applications, but that's not so unusual, not so common, I should say. It's important to think about applicants and inventors in the U.S. So every U.S. patent application must name the inventors of the subject matter claimed. And these are the individuals, the people who came up with the invention, who conceived the invention and helped to reduce it to practice, if you like. An oath or declaration of inventorship must be filed, signed by each inventor with the U.S. Patent and Trademark Office. If for some reason an inventor is not available to sign such a declaration, they're unwilling to sign, they're uncooperative, or they passed away or moved away and you can't locate them, there are mechanisms to deal with that. But preferably, it's much easier to just get that declaration signed as soon as possible. The inventors are also considered to be the applicant of a U.S. patent application unless another entity is named as the applicant. So it's important to make sure that you pay attention to naming the proper entity as the applicant, often the company for which the inventors work. And in the U.S., it's a good idea to get an assignment from the inventors to their company and record that assignment at the U.S. Patent and Trademark Office. There is a very strong duty of disclosure in the U.S. All persons associated with a patent application, and this includes any inventors, any assignees, and the attorneys prosecuting the patent application, have a duty of candor and good faith in dealing with the U.S. Patent and Trademark Office. And this means that all relevant people must bring to the attention of the U.S. Patent and Trademark Office any prior art or other information material to patentability of which they might be aware. This does not mean there's an affirmative duty to search for prior art, but there might be good reasons to do that anyway. And if after doing a search you come up with relevant prior art, that must be cited to the Patent Office. Okay, on the next slide, there is an opportunity in the U.S. to reduce filing or many of the government fees for small and micro entities. Small entity status reduces most government fees by 50% and micro entity status by 75%. That can be helpful. Small entity status is available to individual inventors, small businesses that meet a size requirement of no more than 500 employees, and nonprofit organizations, which can include universities. And also, the small entity must not have a signed or licensed or otherwise conveyed or be under an obligation to convey the application to any other entity that would also not qualify as a small entity. Micro entity status has some additional requirements for individuals. There's a gross income limit and a limit on the number of applications filed, and it's available for certain applications from institutions of higher learning. There are some mechanisms for expediting patent prosecution within the U.S. Patent and Trademark Office once a patent application is filed or once you've determined to file in the U.S. And probably the most likely one to be taken advantage of by a foreign company is the patent prosecution highway. So this program allows a favorable search report that's been obtained in a corresponding international or PCT application or other foreign patent application to be used to expedite patent prosecution in the U.S. for any other countries participating in the patent prosecution highway program. And it's very easy to apply for this program. There's no fee. And once you're on it, you'll pretty much stay on it. So it's a very beneficial program. It doesn't guarantee that you'll get a patent, but it does seem to help speed the process up. There's some other programs to expedite prosecution. Another one that's often used is called Track 1. You can file a petition for prioritized examination as long as the application has no more than 4 independent claims in total, 30 claims total. There is a fairly high fee for that, $4,000 US for large entities. That can be reduced for small entities and micro entities. And there's some other opportunities to file petitions to make special for some technologies and for inventors over 65 years of old or in ill health. And also very recently, there is an opportunity to file for prioritized examination for certain inventions related to COVID-19, some products and processes related to COVID-19. There's an additional requirement that they must also be subject to an FDA approval for those products or processes for COVID-19 use. There is a limit on those applications. The Patent Office is only accepting up to 500 of them, and as of yesterday, I believe there were still 374 slots available, so it doesn't look like it's going to fill up too rapidly. It's useful to talk about some joint ownership issues regarding patent applications. In the U.S., in the absence of any agreement to the contrary, each of the joint owners of a patent can make or use, offer to sell, or sell a patent invention within the U.S. or import the patent invention into the U.S. without the consent of and without consenting to other owners. So this raises a couple issues. It's important to make sure that you've got all your agreements in place to make sure any inventors have assigned to the company. And if you're considering joint ownership in any format, think about how you want to handle this matter. There's sort of a flip side to joint ownership, and that's if you get a patent application that has a patent is issued with a claim that might require two parties or more parties to actually infringe the claim, then you might have an issue showing infringement if, say, one party to perform the step of a method, one step of a method needs to be performed in, or is performed in a foreign country, say, by a third party. It can be very hard to show infringement in that case. A single entity can be held liable for infringement where they direct or control the other entity, or where the two entities form a joint enterprise. That also is something to be mindful of when you are yourself setting up a joint enterprise or any kind of joint development agreement or something with another entity. Okay, so on the next slide, couple things to mention about foreign filing licenses. For patent applications on inventions made in the US, a foreign filing license is required before the application can be filed in another country within 6 months of the US filing date. Applications can be filed after 6 months from the US filing date, as long as the invention has not become subject to a secrecy order. Patent applications are reviewed once they're filed to determine whether a secrecy order is likely or not. And if not, most technologies, that's not an issue, and a foreign filing license is commonly granted, and that's indicated right on the filing receipt. So you typically know that within a matter of a few weeks. It's also, if necessary, it's possible to expedite a foreign filing, the grant of a foreign filing license. That can even be done before the patent application has been filed. For foreign companies, this can arise once they've entered the U.S. and they start having inventors in the U.S. working on patentable inventions. Another issue that is becoming more common now that we've become more of a global global transactional society, there can be inventions made by multiple inventors located in multiple countries, and each of those countries can have their own foreign filing license requirements, or requirements that an application that was invented in that country be filed first in that country. So if that's an issue for you, you'll need to check with someone in each of those countries who knows that law and figure out how you're going to handle that. I'm just going to mention briefly that the U.S. does have some export control laws that apply to data transfers outside of the U.S. separately from the filing of patent applications. This is an area where you'll have to just be aware of it, put it on your radar screen, and consult with an attorney familiar with the export laws of the U.S. Okay, so regarding subject matter eligibility issues in the U.S., and this is on the next slide, this is an area that is in a great deal of flux in the U.S. As I mentioned earlier, the U.S. patent statute sets out what is patentable subject matter, any new and useful process, machine, manufacture, or composition of matter, or improvement of those. There's some statutory exceptions for human organisms and atomic energy, and there's certain tax strategies that are deemed within the prior art. Those aren't particularly controversial for the most part. However, there was a trio of Supreme Court cases, U.S. Supreme Court cases starting in 2012 on what constitutes patentable subject matter, where the Supreme Court said there are certain judicial exceptions to this list of patentable subject matter in the statute. And these exceptions are laws of nature, natural phenomena, and abstract ideas. There's a great deal of uncertainty in the courts that have arisen around these areas, and they do impact life sciences companies. The good news is that within the U.S. Patent and Trademark Office itself, there's a lot more clarity that the Patent Office is trying to provide more clarity to this, and with some success. So it's now becoming a little easier to get patent applications allowed in the U.S. despite having a judicial exception, a claim directed to a judicial exception. And very broadly, the U.S. Patent and Trademark Office is taking the tack that if the judicial exception is integrated into a practical application, then the claim is patent eligible. This has not filtered out to the courts yet. There's still a lot of variability within the courts. So, and it's even filtered down to mechanical inventions, which have been found to be not eligible because they are directed to an abstract idea, or perhaps even a law of nature, which has a lot of people scratching their heads. Congressional action might be needed, but there's no consensus on that yet, and it's not going to happen anytime soon. Just want to mention a couple things on the next slide. The Mayo case, which was the first case that the Supreme Court decided, this was directed to a relationship between a metabolite following administration of a drug and the dosage to be administered. And the Supreme Court found that this was just a correlation that was a law of nature, and the claim was not patent eligible. The Supreme Court set out a two-step test. So if in the second step, if the claim is directed to one of these judicial exceptions, does the claim as a whole amount to significantly more than the exception itself? And this step is where a lot of the uncertainty has arisen. And on the next slide relates to the Myriad case, which extended this judicial exception area to products of nature, in Myriad naturally occurring DNA segments, even when isolated from their natural environment, did not exhibit any markedly different characteristics, and therefore were products of nature and not patent eligible. And the Alice case involved computer-related inventions for mitigating settlement risk by using a third party in a financial transaction. The Supreme Court reaffirmed that this two-step Mayo test also applies to abstract ideas. And even though Alice related to what's known as, falls into the category of business methods, the abstract idea exception has been extended to quite a few subject matter areas, even to the mechanical field. So moving on, I just want to mention a little bit about trademarks. In trademarks, rights actually arise upon use of the mark in commerce. So federal registration is not necessarily required, but it does provide certain advantages. And the U.S. is a member of the Madrid Protocol, so the owner of an international registration can file a request for extension of protection into the U.S. Applications can also be based upon a foreign application or registration in another country. It's not necessary to actually show use in the U.S. prior to registration when you're claiming priority to a foreign application, or basing it on a foreign registration, or for an extension of protection. But you will have to show use in the U.S. at between 5 and 6 years from the date of the issuance of the registration, and every 10 years thereafter when the registration needs to be renewed. Just a couple of comments on some recent U.S. Patent Office regulatory changes regarding enhanced requirements for email addresses, more rigorous vetting of specimens when needed to show use, and there is a U.S. licensed attorney requirement for applicants domiciled outside of the U.S. And on next slide on copyrights, the U.S. is a member of the Berne Convention for the Protection of Literary and Artistic Works. Copyrights protect original works of authorship, fixed and tangible medium of expression. And I think so registration is not necessarily required, but based on because of the Berne Convention, but and on the next slide, there are some benefits to filing a registration and to obtaining a federal registration at the U.S. Copyright Office. I also just want to mention that in the U.S., the burden of policing copyright protected art works on the internet falls to the copyright owner, not to the internet or online service provider. There's a statute, federal statute, the Digital Millennium Copyright Act, that provides a procedure by which copyright owners can request an internet or online service provider to take down an infringing work. And then finally, on the last slide, I believe, I just want to mention a little bit about trade secrets. In the U.S., all of the states provide protection for trade secrets in some manner. Fairly recently, the Defend Trade Secrets Act, enacted in 2016, provides a civil cause of action in U.S. federal courts for trade secret misappropriation, in addition to the state trade secrets. And there are other federal statutes that provide criminal penalties. So I think we're kind of coming to an end, so we want to leave some time for questions. And thank you very much.
Okay, thank you, Eugene and Beverly, for that interesting presentation. So please submit your questions in the chat window. Click on the chat button and then submit your questions to the host there. The first question, are there drawbacks to formation only in the home state, other than Delaware, where the primary office is located?
Good question. I'll field this one. So it'll depend on the state, because as I said before, there's no, federal U.S. corporate law. So every state has its own statutes governing formation and governance of U.S. corporations. Many states have, equally business-friendly laws and a sophisticated jurisprudence like Delaware. So there may not be many disadvantages in that respect. Other states, have more stockholder-friendly laws, like Massachusetts. Some have less developed bodies of law, so there's less predictability there, which could be, seen as a disadvantage. Another big thing to think about is professional investors. I mean, if that's something that you're considering, if you're considering going public at some point, professional investors really like Delaware corporations. So if that's an objective, in the future, then you're probably better off forming in Delaware in the first instance. Hope that answers the question.
Okay, thank you. And I do want to clarify for all the attendees, we will be emailing out the recording of the webinar as well as the presentation slides afterwards. The next question, if the U.S. subsidiary transfers data to the foreign parent company during the course of regular business operations, would this be subject to the export control laws?
I can not entirely provide an answer for that, but I think since it's outside of the IP issue or IP area that I deal with, the answer is probably or maybe, and it's something that you should speak with an attorney versed in the U.S. export control laws on. It's often not a problem depending on your technology, but it can be very easy to deal with that, to have a policy in place to show that you've paid attention to this issue and that you're doing whatever you need to do to make sure that you are abiding by the U.S. export control laws. If your technology is going to involve some defense technologies or weapons or arms or something like that, there are probably going to be more stringent requirements. But what those requirements are you really need to speak with an attorney versed in the U.S. export laws.
Okay. The next question, how is useful process defined by the U.S. Patent and Trademark Office? Would a new and useful business process be patentable?
Oh, that's a really interesting question. So So the statute requires that inventions be new and useful and also unobvious. And typically, the useful requirement has not been considered a very difficult bar. As long as there's some utility, some practical application, you're going to meet that requirement, as opposed to, for example, an ornamental feature, which would put you into the design patent application area, where you'll still start running into problems is, and particularly with business methods, is the judicial exceptions. So, and probably the abstract idea judicial exception. If you're going to file an application on a business method, it might be very useful, but it will also be considered an abstract idea, and that's going to be the hurdle that you're going to have to get over. If you can, if it's technological field of use, so to speak, is in the business world, if you're improving the technology of a computer or making some other kind of technological improvement, that can go a long way to helping get over the abstract idea hurdle. But usefulness itself is not going to be that much of a hurdle. It's more the exception problem. Hopefully that helps a little bit.
Okay. The next question, what are the pros and cons of maintaining a trade secret versus filing a patent?
Yeah, I can help answer that one a little bit too. So there are a lot of considerations to go into whether something should be maintained as a trade secret or whether you should file a patent application on that. Some trade secrets are not patentable, like your customer list, so there's no question there. Trade secrets have to be able to be maintained in secrecy. So if a third party can reverse engineer the secret from purchasing your product or independently develops the trade secret, then trade secrecy is not going to help you protect against that third party. Trade secrets are typically less expensive to protect and maintain. You don't have to go through the process of drafting and filing an application and doing it back and forth with the examiner. Trade secrets, in principle, last forever. They'll last until they are no longer secret. Patents have a lifetime of 20 years from the earliest filing date, not including the provisional filing date if you base it on the provisional application. So they do have a lifetime end, with some exceptions for that. There are some ways of extending that period, but they do have a finite lifetime. Trade secrets you need to take steps to maintain the trade secret, which can include a lot of things, including dealing with your employees. You might need some strong employee agreements, particularly with some key employees. But everyone should understand that there are trade secrets that cannot be divulged to people outside of the company. Steps need to be taken for physical security and computer security. So those can be costly. But ultimately, it can be very expensive if you have to bring suit for misappropriation of trade secret. If you ever find yourself in that position, then that can be costly. So there are all of these trade-offs that need to be thought about.
Okay, thank you. Okay, so that is that's all the time that we have. Thank you, Eugene and Beverly, very much for taking the time to share your expertise. We really appreciate it. And please watch our website for future upcoming webinars at actionnewengland.org. And thank you very much for attending the webinar today. We hope you found this informative. Thank you and have a good day.
Thank you all.
Bye-bye.